this is full screen, yeah. Usually there's something in the side, but doesn't seem to be a... Okay, right. No, I wanted to see more. Yeah, okay.
Just to let you know, we're live streaming now. Sorry? No worries. 63. Okay, thanks. Bye. Bye-bye. Council ready to go? I'll just check. Similar they are. Just a reminder about mobile devices to mute, thank you. Sorry, of course ready when come up this open. Right, I want to come up now. Thank you. Let's go through. Thank you.
Yeah.
Or something like that. All ready. Thank you.
Court rise.
Yes, Mrs. Branch. Lord, just a few clarification points as to the structure of the appeal. I think it's clear, but just to make sure it is, below and before you, we don't just rely upon the WP communication in support of the risk of dissipation. As as I'll come to in a moment, it was certainly before the judge. We spent the majority of our time on the jury instructions and the complaint and the behaviour of Hytera prior to the WP meeting. And so it's wrong to suggest that that's a new point we've embarked upon on this appeal. It was always one of the key facets of our case below. And indeed, the judge
No, I
considered
don't think it's suggested it's a new point. I mean, what is being said is that but for the without prejudice material, the judge would have found what the other things that you relied on weren't enough.
quite.
And that's the subject of your respondent's notice.
Exactly. The second is just into as to how the appeal might be determined. It's put that the appellant only needs to succeed on one of the two grounds to succeed. We don't agree with that. If they succeed on the what I call the evidential basis, two things have to happen. One, you have to consider whether the judge's conclusions would have satisfied the new test that they advance. And second of all, if you're with us on the respondent's notice, we still prevail.
Yeah.
So I put it like this: unless they win on unambiguous impropriety, they lose. And lastly, my lord, just a point of context. If you could take up supplemental bundle volume 1, not of the authorities, just of the documents. My lord, you were posing a question to my learned friend about what the Court of Appeal and what Part J were doing in Dora, exactly where it fitted into the sort of procedural hierarchy. If you look at tab 1 of this bundle here, this is the strikeout notice that the appellant filed.
Yeah.
And if you go to page 3 of that document, and you go to the last paragraph, there they ask that the strikeout application, so the strikeout of the WP evidence, be heard and decided at the hearing before the freezing order application. Now, we'll come on to later exactly what transpired and what that means. But if you go back to Dora, what happened there was the case was filed, there was a freezing order application, there was an application to discharge the freezing order, and in the interim, the case came before Parker's to the admissibility of the WP material. That was determined, and then into the future there was a discharge hearing, freezing order. So I don't know whether this was by design or coincidence. That is what the appellant proposed to do here. And what I say, that is significant given all we've heard today about the evidential standard, because what they should have done is turn up before Mr. Justice Jacobs and say, we want this determined. You've got the two competing witness statements, the two confidential annexes. Either we want everybody cross-examined or we're happy to do it, but this has to take place first before we do the freezing order application. Having not done that, and having not taken his lordship to the new formulation of the evidential basis that they now say applies, they can hardly come back before you and try and do what they should have done before, or
So
say...
you say they should have what? Should have asked for the trial of an issue?
Well, it's an application...
Before the application...
They should have asked for the determination of the application to strike out, and it was for them to advance before the judge how that should take place. Now, if they thought it should be like a strikeout on the evidence before the judge for him to reach a conclusion, or there should have been cross-examination, it was incumbent upon them to pursue that and push it. What they couldn't do is not say much about the evidential test, advance a different one, and then appeal and say, you should have applied this one. And by the way, we didn't have a trial because we didn't press this application. And what happened in the event is the application, this application and the freezing order application were effectively dealt with at the same time.
Well, what would have happened if the judge had decided that the exception was not made out and that the material wasn't admissible?
Well, if he'd, and we only had a day on the 7th, if he'd taken up a day on this application, which I think is probably realistic, found against us, said you can't rely upon it, there would have been a hearing in a matter of weeks, I would say.
Before him or before someone else?
I think that probably would have been a creature of commercial court listing rather than anything else. Maybe the judge would have said, I reserve it to myself because I have the background. Maybe we would have said it's inappropriate, or they would have said it's inappropriate for you to have it. But there would have been another hearing at which we would have had to persuade him or another judge that we had other good grounds for risk of dissipation.
You say they didn't say much about the evidential test. You're not submitting, are you, that the point they're now taking is not open to them because they didn't?
I'm not saying not so much that, but if you decide that neither the test we advanced or the test they advanced applies, so in other words, a new test, we can certainly say to you that the freezing order should be upheld based on the judge's findings that he made as to the assessment of the evidence on what happened at that WP meeting. So perhaps if I could turn then to the authorities, and I would just call this a sort of sweep up, so you have what I say are key passages of the relevant ones. And
Sorry, just before we go to the authorities, and just look at your amended respondents notice.
yes,
You don't, I think, say, even if the judge applied the wrong evidential threshold to the without prejudice material, that material satisfies whatever the right test is. Your respondent's notice says, well, even if you don't look at the without prejudice material, we're still entitled to the injunction.
that's correct. The point about if it's a different test, it's still satisfied, is our response to their advance of what's been called in their skeleton the prima facie test. So what we say is if that test applied, if you look at the judge's conclusions, it satisfied that test.
Right. You want us to go to the authorities?
Yes, please. And it's predominantly in the core bundle. I'm going to start with Berry Trade, and that is at tab 2.
Tab 1 in mine.
My apologies. Yes, tab 1, you're correct. Mine's become electronic and doubled the memory. So, if we could please take up paragraph 32. This is the judge's commencement of his analysis of the law. And it's really the last 4 sentences of the quote from Cutts v. Head. And if I could kindly just ask you to read that. And of course that was pertinent in this case because here there was a summary judgment application about an issue that would be determined on the merits at trial if there was no summary judgment. And so the focus was obviously upon whether admissions had been made or not. And if we could please pick it up at paragraph 40 and 42. And this is a point that's received a reasonable amount of airtime, so I can take it quickly. But the simple point here, this wasn't a disapproval per se of DORA, as we see in paragraph 42. It was distinguishable on the facts. And if I could kindly ask you to read the first 8 sentences of paragraph 42, you'll see the basis of the distinction.
Yeah.
So that, I say, highlights the importance of distinguishing between a case where you are dealing with something somebody allegedly said at a WP meeting that is then going to be used against them to establish a fact that's relevant to the merits of the trial. And our case here, or the case of Dora, where it's simply a quite simple question of whether a threat was made to move assets. The only other point in Berry I wanted to highlight is if you could go to paragraph 56, and this is a passage we've already seen, but you'll see there satellite litigation of this sort is bound to discourage settlement negotiations for fear of such consequences. Now that is probably a fair point, but I say that supports our theory that the way this should be addressed in the context of freezing orders is a good arguable case and done on the basis of the kind of evidence that the judge had before him, rather than having satellite litigation. And that approach would not cause the problem here that the judge was concerned with, which is to discourage settlement negotiations for fear of such consequences. Because, as I said earlier, if you know you can explore all facets of your case on the merits at a mediation or a WP meeting, but you just can't make improper threats, then you have no such fear. And the idea that there's not going to be mini trials or satellite disputes about that won't arise.
So what is the defendant to do? The claimant comes along and says, look what they said in the without prejudice meeting. It's terrible, isn't it? The defendant might say, well, I'm not going to respond to that because it's all without prejudice, in which case the claimant will say, well, my evidence is not challenged. Or he might say, no, that's not right, what happened is this. In which case the claimant will say, well, that's a dispute you can't decide. There's a plausible evidential basis because look at my evidence. So it's got to be omitted. So the defendant has something of a dilemma by which he seems not to be able to win on your approach.
No, he can certainly win. And he can win in this way. If there's an allegation that they've been made, and like in this case, there's a freezing order application and it's relied upon, they can apply to strike it out. And if it's a good arguable case standard, and I'm going to come on to how I say the good arguable case should be shaped. But the critical question is, good arguable cases to what? Now, we're all very used to oligarch type cases where it's a good arguable case as to some very convoluted fraud, and the court has to reach a view on whether that's got whether it's a good arguable case, and at a trial in 3 years it will succeed. So it's a very complex, intricate exercise about something that's going to happen in the future. Here, good arguable case as to whether at a meeting somebody made a threat about making themselves judgment proof. If you have a case, particularly if there's some contemporaneous evidence, and you have a case where it's plausible given the surrounding circumstances, the defendant's choice is to put in all of the evidence that it wants to rely upon, ideally from direct witnesses and any contemporaneous evidence that supports it, and says, well, they don't have a good arguable case that was a threat. So that's the defendant's choice. And because...
But wait a minute. Suppose the defendant does all that.
Yes.
And the judge says, well, I think it's pretty evenly balanced here. I don't think I can decide between those two versions of events. So it's a good arguable case from the claimant's point of view. I'm going to grant the injunction. Can the defendant then say, right, well, all right, you've granted the injunction, judge. Now I want a trial of whether I did say these things, because if I didn't, then you shouldn't have granted the injunction, and I want to enforce the cross-undertaking in damages. Can you do that?
No, because the defendant's choice is to do what the appellant did.
Well, then
here.
he's absolutely stuck, as my lord says.
Well, he's not stuck because he's not stuck if he's got bad evidence and he can't disprove the allegation. He's made an improper threat. And you look at it this way.
But no, I don't think you're grappling with my lord's point. That here you have two perfectly plausible cases put before the judge.
Yes.
Eminently respectable people, one of whom says he said X, and the other one who said, no, I didn't say X. And even if I did say X, you've misinterpreted X. That, on your approach, that question is never going to be finally resolved.
That's correct. It will not be finally resolved. And it will not be finally resolved because, like in this case, The freezing order is pursuant to Section 25 of the Civil Jurisdictions and Judgments Act. It's in support of the enforcement of a foreign judgment. So when that comes to trial, it won't touch upon any of these issues. No. But the converse is true too, in the sense I don't really see how, on my learned friend's formulation of the test or the approach, a claimant is ever going to be relying successfully on a threat made at a WP meeting to make themselves judgment proof. Because what if they allege it and it's denied, it's not permissible on his test, because you won't overcome a higher threshold. And I would suggest here that whilst you can construct a hypothetical, as Lord Justice Males just has, where it's very evenly balanced and it's difficult to tell, but in my respectful submission, in the vast majority of cases with experienced commercial and chancery judges being faced with competing witness statements, contemporaneous evidence, they're going to be able to tell pretty clearly on a good arguable case who is right and who's not. It's almost a binary question. And if we look at our case...
Well, that's right, provided on the premise that your good arguable case is the correct test.
Yes. And I might say, although we're not at it yet, that the distinction between the prima facie test that I understand now to be advanced and a good arguable case is, I say, a distinction without a practical difference. And again, I go to the nature of the inquiry. If you look at each of the authorities, what the judges were faced with there was something was said, 80% say, for example, wasn't contentious. The other 20% was, and there's a real battle about what those words meant. And we see that in Furster and Furster, we see that in Sengar, and we see it in this case. And so what the judge is looking at is what was the implication from those words. And that, when you're looking at a good arguable case as a standard, or a prima facie standard, in my respectful submission, you are unlikely to come to a different result. And if you look at this particular case, although it was in answer to a point made by Mr. Rubin, who appeared at first instance, about the plausibility, he weighed up the fact you had a direct statement from one of the participants, some contemporaneous evidence supporting it, in the form of the picture of the flip chart. What was being contended was plausible given the overall context and the links between what he was saying and the contents of the flip chart. And then when the defendant, the appellant, came and stepped in, they didn't deny that the conversation took place like in Dora. They didn't even deny that things like retreat, China, Russia, Africa were spoken of. And they didn't even deny that there was a connection between the retreat and those. They simply said, well, that was a reference to commercial realities, not to make us enforcement proof. And it was not given directly, it was given through a solicitor on information and belief, rather than through the three Hytera attendees.
So I'm sure that's right. They gave quite a full account of what they said had happened at the meeting, including the fact that it was Motorola who had first talked about the question of enforcement.
Yes.
And they gave an explanation for some of the figures on the flip chart, which your evidence had not addressed.
Yes, so you certainly have an account, but you would expect, in a case of this importance and contention, and on such a crux issue, to have evidence directly from those who attended, particularly if you're saying it's all terrible if we don't get the opportunity to have a trial, or there's a high evidential burden that needs to be applied here, but yet you don't put in key evidence from those who are actually in attendance. And that's on the background of having essentially and literally taken the fifth in the Illinois trial. And the other thing, my lord, on that is that evidence that comes...
the people who took the Fifth Amendment in the trial were not the same people who would be giving evidence on what happened at these meetings.
No, that's true, and it was the three Hytera recruits
Yes.
who literally took the fifth
Yes.
in the trial, but the Hytera senior management did not give evidence at the trial either. That's Mr. Chen and Mr. Zhu.
Yeah.
So, my lord, going back to the evidence that they did present, rather than contradicting Motorola's version of events, it supports it. What happens in a meeting, logically, if one party says, following Motorola versus Lewison, we're very good at enforcing judgments, and we've got lots of experience, and we'll follow everywhere. The natural reaction is, well, if we get an unacceptable result, we shall retreat, and we'll go to places like China and PRC and Russia that are murky. So I say that what you do get actually supports Motorola's case rather than
I'm not sure
undercuts it.
why you were so quick to say, in answer to my Lord Justice Lewison, that there could never be a hearing as to what happened, because you did give an undertaking in damages.
Yes.
One can quite see that a freezing order would cause loss as a result of not being able to make payments from accounts or whatever. Why couldn't Hytera come back and say, we never had, look, we've paid the judgment, we never had any intention of not paying the judgment, and we've suffered loss because you unnecessarily froze all our assets and disrupted our business? Why couldn't there then be an issue?
My apologies, my lady, if my answer wasn't absolutely clear. What I meant by that is, unlike, say, Berry and the other cases, where there was going to be a merits trial on the issues of the admissions, here there wouldn't be a trial per se. But there could be two opportunities where a trial with evidence, say examination of witnesses, could take place. Firstly, on an application like they filed, they could have required that witnesses be heard at that. They could have applied for that. And so there you'd effectively get a trial. And then, obviously, Your Ladyship, your example, if they sought to discharge an injunction and wanted to make a claim pursuant to the undertaking, they could adduce evidence then. So those would be two examples, but they would not be an example of a trial on the subject matter, on the merits, like in the other cases.
Who was Mr. Tucker? I couldn't see who.
Mr. Tucker is now, I get confused. There's a Mr. Tucker who's a Motorola employee.
No, the one who was at the meeting on the Hytera side.
Oh, Hytera side. My understanding is he was an advisor or consultant for Hytera with respect to the US litigation, in particular the settlement meeting. And just one last point on that, Lord Justice Mayles, the sort of the substance of the meeting. If you look at what was said to the judge at first instance and is in his judgment, it's not like in Dora where there was just a bare denial of what was said. Words like misunderstanding and different interpretation were used. And that, I say, goes to your first question about, is a defendant in a difficult position? Well, a lot depends upon whether they've made the threat or not. They've certainly got many ways open to them to defeat the reliance on the WP communications if they haven't made a threat.
Well, isn't that a bit like the situation that Lord Justice Simon Brown was considering in Alizadeh and Nikbin, where you've got things that could be interpreted one way, could be interpreted a different way.
Yes, and I think
he says that's not unambiguous in propriety.
Well, my lord, two things. First of all, you've got to remember the context of that case. So that was the two Iranian pals and property developers who fell out. And if you take a look, my lord, at
Indeed, so what I'm looking at.
Yes.
He says that's one possible interpretation to take, one inference, indeed probably might be thought the more probable explanation.
Yes, and if you go to maybe the bottom of page 6, what he's doing there, and the evidence, and my lord, perhaps if you just pick it up, the second paragraph on page 5, so you get the context, because the transcripts were in Farsi and then translated, and as you can see there, it wasn't the easiest exercise to understand what was being said. And that's really the crux of it, my lord, because there, the party relying upon it wanted to have a field day in cross-examination because it would allow them to pursue things that could be said to be admissions against the other party on the merits at trial. So this was not a freezing order case, and this was a case where the party alleging the improprietary was seeking to pursue admissions at trial. And if you go back to...
But mustn't the test of impropriety, unambiguous impropriety, be the same whether you're trying to rely on admissions or trying to rely on something else?
I think that the test is... It's a different context, because when you're talking about admissions, you're looking at the public policy. Free to speak at WP meetings. Free to be able to say what you need to say to try and settle, so you can go to trial and not worry about what you said being picked apart. That's not an abuse, and that's what all of the authorities say. You are not abusing the prejudice if you speak freely at a WP meeting. That does not apply, and so it's you look at it through a different lens if you're making a threat, because the threat's got nothing to do with admissions at trial, and so the public policy isn't being offended. And the balance, and if you distill it down, my lord, what you're really doing is a balance between the abuse on the one hand, the prejudice and the offence to the public policy on the other. In cases like ours, the abuse is significant. You've done something improper at a WP meeting. You've made a threat. The prejudice to you at trial is non-existent because there isn't going to be a trial. And the public policy isn't undermined because it's not stopping you at a WP meeting speaking freely about the merits. Now, as we've seen in its common ground,
Making a threat of itself is not necessarily improper, is it?
No, I guess it depends on the threat. If it's, I'm never going to buy you a drink after this because we'll fall out, that's not improper. But if it's clear from what you have said that it doesn't matter if you're good at enforcing judgments, and it doesn't matter that there's $400 or $500 million in Western Europe and the United States to be pursued, we're going to retreat to China, Africa, and Russia because they're murky jurisdictions. That is improper. And my lord, it's I struggled with this because when I read the appellant's papers, improprietary suddenly meant to me fraud or something like that. If you look at the Oxford Dictionary or Black's or any of the dictionaries, it's unbecoming, unseemly, inappropriate. It's a low test in terms of what you are looking for in the context of unacceptable conduct.
Well, if you read the whole phrase, which was something like perjury, blackmail, or unambiguous impropriety, it takes its colour from its friends, doesn't it?
Yes, yes. And that's an
It's
important...
not just talking about something which is unbecoming.
No, but it's... and this is where the Black's definition, which isn't before the court, but it's the appearance of improper conduct. And it is, and I say this with some passion, it is not proper to say I'm going to make myself judgment-proof. And the best evidence that it's improper is that the test for risk of dissipation of assets is that the party that the relief is sought against, there's a reasonable belief that they will take steps to make the judgment unenforceable or more difficult to enforce by improper measures. And I'll come on to improper measures in the context of this case shortly, but just to be clear, you can undercapitalise, transfer assets, change recipients in lawful and in unlawful ways. And if there's an acceptance that there is, on the whole of the evidence, a risk of dissipation of assets, the fact that the methods that you are going to use may, on one view, be lawful, doesn't make the threat improper, and doesn't make the means by which you're going to do it lawful. You could undercapitalise a company perfectly legitimately. You could also do it because you want to get cash out of the jurisdiction and be breaching directors' fiduciary duties to creditors because you're not leaving enough in there for future debts. We don't get into that in the context of freezing orders because we're looking at a good arguable case. So to Lord Justice Lewison's question, yes, not every threat is improper. But certainly here, in the context of saying that a judgment won't be enforceable because we're going to take measures to ensure it's not, that is plainly improper.
Coming back to what Justice Simon Brown in Fazil Alizadeh, page 7,
Yes.
He seems to be saying that even if the defendant's account is the more probable explanation of the plaintiff's comments, it's quite another thing to contend that this is the unambiguous conclusion. Isn't he saying there that even something which is more probable than not does not satisfy the test of unambiguous impropriety?
Yes.
And if that is what he's saying, isn't there a clear conflict between that and Dora and Simpa?
No.
No?
No. And the reason is this, because what the judge is doing there is essentially assessing the evidence, taking it at its highest on the basis that it's established, and saying that the quality of what's happened here isn't unambiguous and proprietary. And the reason he says that, and he says it about the other issue that was in dispute in this case, is because simply because you're a litigant and you turn up to a WP meeting and make some admissions about here whether a £10,000 advance was a loan or not, just because you do that doesn't then mean that you've done anything improper, because that's the whole idea of mediation. You reel your hand and then you turn up to court and you're free because of the privilege to pursue whatever other arguments you like. So here there's no threat involved. It's a question of whether there's admissions, and the court quite rightly is saying there's nothing improper about taking a contrary position at a WP meeting. So even if I accept that that was the content of the discussion, it doesn't amount to anything improper, because we're only talking about admissions for trial here. And if you, to make good that, if you go over the page to page 8, just read the penultimate paragraph. So it's effectively putting a wall around discussions that may be relied upon later as admissions to facts on the merits. Could I please ask you to take up 5A, the same authorities bundle?
What a 5A? What's that? Oh, interactive technology.
That's it, yeah. So Lady Justice Rose will no doubt be familiar with this decision. This was the case regarding the warring brothers, and there was an email sent following a mediation, and you can pick that up at page 2. The contents of the email. And it's really paragraph 3.
I'm sorry, do you have a copy of that? I have looked at it electronically, but my 5A turns out to be the copy of Gang Shipping, which I thought I didn't have.
Yes, I'm sure we can hand up
Thank you
a
very
hard
much.
copy. I've only got electronic copies.
I understand
myself.
that. That's very kind.
Oh, thank you, Alex.
There's another copy.
I've got a copy.
I think it's just me.
You can give one back if you want.
Thank you.
This one, we're on page 2.
Yep.
We're just looking at the email.
Yes.
And you'll see there, it's really paragraph 3, 5, 8 and 10, which were the controversial paragraphs.
And 6.
Yes, it may be best if you read all of them, so you have them. And if I could ask you to turn to paragraph 13. And there I say is that, again, the distinction drawn between, obviously we're a less extreme species, but we're still in the blackmail group rather than the admissions group of cases. And that's why in the previous authority we were looking at, where you were referring to Lord Justice Mayall's, the question of whether that was unambiguously improper. The reason it wasn't there is because it wasn't, like in this case, a more straightforward abuse of the privilege, and because you're not offending the public policy, because you're not dealing with issues that go to the merits. And then, if I could ask you to take up paragraph 15, please. And there's a discussion there as to Dora and Simper. And there's a similar conclusion reached as to the criticism of Dora by the Court of Appeal in Berry. And at the close of paragraph 15, I say our case, although not as clear-cut, is of a similar type of here, in that what was said, we couldn't describe it as very clear, but we could describe it as reasonably clear as to the issues that were discussed. And I start with retreat and go through. But there was a dispute about how that email should be construed. Well, there's certainly, and I'll take you to the passages of judgment in a moment, there was certainly a dispute about how it should be construed. And indeed, Mr. Rubin's position below was that it was really just a misunderstanding, a mix of cultures. So, like in this case, what the judge was faced at first instance was the main body of evidence pretty clear as to what had been said. I mean, it was really just about what that meant, and whether it meant what Motorola said, or whether it meant what Hytera said. And then, just at paragraph 18, here is an assessment of, a similar assessment we say should take place in our case, as to whether there was any ambiguity as to the improprietary. And here again, it's not entirely analogous, but it's fairly similar. What was being said is, you can get as big a judgment as you like. You're never going to recover anything because we're going to retreat. And therefore, you should accept the very low offer we're making. Here it was somewhat flipped around in the sense that we're going to do all of these things unless you pay us more than we've requested so far. I think the number in the end was 25%. But if that's improper, then why is it not improper to say, do your best with the judgment, we're not going to allow you to recover it, and therefore take a much lower amount?
Well, it partly depends what you mean by retreat.
Yes.
You also overlooked the first part of the response, according to your evidence, which is appeal. There's nothing wrong with that.
No, nothing wrong.
And so far, as we have seen, they have taken the legal procedural route to challenging the Illinois judgment. They've filed post-trial motions. They say they're going to appeal. So it's, I mean, even at the highest on your evidence, this is the retreat is an alternative to appeal, and they are pursuing the first of those, not the second.
No, my lord, that's not quite right. My evidence on the highest is Mr. Nuera's evidence, which is clear that they said this is what we're going to do. Well,
I don't think it is with respect. He says they were going to appeal or retreat.
He certainly says that's what the flip chart said, but what he then goes on to say is this is what they said they would do, and then they gave express examples of how they were going to do it. So I accept that on the drawing there is a two-pronged approach. Doesn't necessarily mean they're exclusive, but when you go to the evidence of Mr. Nuera and the assessment of whether that was plausible, it's very clear that these were things that they were going to do, and they gave examples of how they were going to do it. And if you look at paragraph 22, here Mr. Hollander, who was appearing for the two brothers, it's a summary of his attempt to explain away the emails and the contents, and that's a little bit like what's happened in this case. Mr. Rubin at first instance sought to explain them away, and the judge rejected those explanations and considered them not plausible. And so what is relevant from this to our case, and I'll go to the appeal decision in a moment, is that there is inevitably...
Did you say the defendant's evidence was not plausible, as distinct from the fact that yours was?
You're correct. He endorsed the plausibility of the Motorola evidence based on some factors. But I would... the flip side to that, in my respectful submission, is if we're plausible, is what we're saying is plausible, and there's a direct contradiction between the two, it's implicit that their explanation is not plausible.
Well, not necessarily. My lord's example was of two accounts, each of which is plausible. That's the experience of trial judges up and down the country every day.
True, but not this one in this particular case.
Okay.
So what we say is this, that in all of these cases, you're inevitably going to get an area of disagreement about what was actually said. And you are always going to have clever counsel for both sides presenting arguments as to which is most likely or what was actually meant. And that's why a test like good arguable case on a fairly narrow, almost binary inquiry about something that has already taken place is an appropriate approach. So 5B ought to be the Court of Appeal's decision. And I could just ask you to take up and read paragraph 11. And Lord Justice Lewison, hopefully this answers the question that you put to me earlier about is the test different between an admission and a threat? Probably more clearly than I was able to articulate. Although the test remains that of unambiguous impropriety, it may be easier to show that there is an unambiguous impropriety where there is an improper threat than where there is simply an unambiguous admission of the truth.
Yeah, thank you.
It isn't in the unambiguous admission of the truth. The implicit threat is that I'm going to say something different at the trial.
Yes, but it's not the party seeking to pierce the veil of the privilege and complaining of an abuse isn't directing it towards that threat. What they're trying to do is to get that evidence and to be able to rely upon. And that's why in Berry, I took you to the distinction where the judge said it's not that it was made, it's the truth of it. That's the critical distinction. So it's not the threat, I'm going to go to trial with a different story. It's what you then do.
But you're relying on what you say happened at the meeting for its truth. This is what we will do. Not merely for the fact that it was said.
Well, slightly differently, I would say. I characterize it as a threat, and I say I've got a good arguable case it was a threat. And therefore, and we'll obviously turn to the evidential test that needs to be applied, but assume it's accepting what you say is correct. Is that an unambiguous impropriety because it's a threat? I say yes, absolutely.
Accepting what you say is correct. No, it's not that with respect. It's accepting what I say you said is correct.
Yes.
You're not accepting what Hytera say they said.
No. But if I have the benefit of a good arguable case standard and I overcome that, then the position is what my contentions as to what took place are established.
And what you said was, Mr. Shue presented two options: one, appeal, or two, retreat to China. As part of Hytera's retreat to China plan, Mr. Shue said Hytera would do at least the following. So the plan is presented as alternatives, and I don't see how at the moment you get away from that, because Mr. whose name is second witness statement doesn't try to qualify that.
Yes, and that may be true, my lord, but what does appeal mean? Does it mean successful appeal? I mean, it's not clear, and it doesn't mean that the threat, the actual threat. Remember, we're talking about a threat. It's not what they actually do in the future, because you would hope the whole purpose of it is that they can't do it in the future because we get a freezing order. So if I make an improper threat to do 5 different things, and this is a little bit like Firster and Firster, we're going to file contempt, we're going to tell the press, we're going to ruin your life. I mean, there was 4 or 5 things. It's the making of the threat that's improper. The fact that it may be one of 2 things and one of them's lawful and one's unlawful doesn't, in my respectful submission, make a difference. If that was the case, I could walk into a meeting, make 5 proper contentions and 1 improper one, and say they're all in the alternatives, and the privilege would never be abused. And what's interesting, my lord, is that I would say you can draw this, that the 2 alternatives were given. Somebody from the Motorola side said, we're very good at enforcing judgments. And then there was discussion about specifics of how they would retreat. So it doesn't naturally follow, just because there were 2 options, that threats weren't made in relation to one of them. And just lastly, in the Court of Appeal decision, if you could look at paragraph 19. And because I think Hytera relied upon it, perhaps paragraph 20 as well. And two points arising from that. The first is, we say our case is not too dissimilar to what is described in paragraph 19. Hytera, in a meeting where a multi-digit million judgment and enforcement was being discussed, was effectively saying to Motorola, take less, because we're going to retreat, and therefore you should accept the lesser amount. I know it's flipped in terms of less or more, but it's still very much the same. They found a way of trying to threaten us to accept a lesser amount that was outside the merits of the underlying case. And the distinction that's referred to in paragraph 20, we say doesn't arise, whether it's an increase or a decrease, as long as it's unacceptable or unreasonable. And we've got evidence from Mr. Nuera on that. So I think the last, just very briefly, the last couple of authorities I want to show you, I can take more quickly. Kuwait Airways, you have, that's at tab 8, I believe.
Well, you said this was an LPP case.
Yes, and I think, my lord, you have my point on that, so I'm not going to advance it. But if you were against me on it and said, yes, it is somehow analogous, if you could just look at the whole of paragraph 37 on page 2748. And it's really the last sentence.
Yeah.
And here, that's the same. There's not going to be any prejudgment of an issue to be tried. So even if that higher standard applied, we would satisfy it. So, ocean bulk, if I could just, that's tab 9. And it's paragraph 28 on page 677. And again, if I could just kindly ask you to read the quoted passage there and focus on the word "speak freely."
From Lord Hope.
Yes, exactly. Now, as I've made the point before, I'll just repeat it briefly. If Dora and Mr. Joseph Jacobs' decision are upheld, that public policy, we say, will not be offended with respect to admissions. And we ought not have a position where the law effectively endorses threats to make one self-judgment proof at settlement meetings. The last passage of this decision I draw your attention to is paragraph 32, where there's a quote from Lord Justice Robert Walker, where he listed out the most important exceptions. And I don't need to read them out to you now, just to note that there are a number, and they are for reasons that amount to a lot less than fraud or crime, such as you find with LPP. And the appellant's attempt to buff up this exception as a really seen beast that has some awful erosion on the privilege simply isn't correct when you look at all of these exceptions. And the last one is on page 679, which is the matrimonial cases exception. And finally, on those cases, before I finish up with Dora, what is important is that other than Dora, they are all cases dealing with interlocutory applications with respect to something that will be addressed later at a trial by way of admissions. I think you have my point on that, but just to be clear. If we could go to, please, tab 3, which is Dora. And I'd like to start on page 2. On the 4th paragraph down, Lord Justice Lewison had some questions as to sort of the context of all of this, where it was procedurally, and we see the answer there, that there was a Morava injunction due to be heard in March. And the real question was whether Mr. Forsyth's evidence was admissible. So really what was before the court then was the equivalent to the application that we see in tab 1. Could, in the context of that freezing order application, this evidence being relied upon as admissible? And then bottom of page 3. And we have more on the admission cases and the distinction between the cases the type of case that we're dealing with in Dora. I don't think I need to trouble you with the balance of that paragraph, but I do wish to draw your attention to the second paragraph on page 4, because that tells us what submissions were made. And so how it was approached by the court, and it's the second one that's particularly pertinent. He submitted that the statements were at least capable of being understood as a threat of impropriety, and that it was a threat to put assets of the company and the two directors beyond the reach of the court's judgment by improper means. I think we've covered the rest of that passage of the judgment, but if you could take up page 7, please.
Is that a test that you're advocating for? That the test is that something is at least capable of being understood as a threat?
Yes.
That's good enough, is it?
That's good enough.
Now, the threat here
Yes.
was transferring the business to a new company so that old PlaySafe would have no assets. Not moving assets, but that they would not have any, anywhere.
Yeah.
That's the threat.
Yes. It's obviously a simpler case, but in my respectful submission, there's no practical distinction between saying we've effectively got one asset and we'll transfer it to another company, to saying, well, we'll undercapitalise all of our cash, we'll switch our receivables to a Chinese company, and we'll change ownership of things. And obviously we'll come to the evidence in a moment, my lord, but just because the steps to make yourself judgment proof were simpler in Dora doesn't mean that the principle doesn't apply to our case. So subject to any questions on that passage, if I could just ask you to look at the judgment of Lord Justice Alton on page 7. And it's the passage I'm most focused on is the third last, starting the words complained of were, in my judgment, directed to a collateral matter. The words were capable of bearing the meaning that if the plaintiff was to pursue what he perceived to be his legal rights and remedies, and some of the defendants would ensure that the first and second defendants would so conduct the affairs of the third defendant as to ensure that there would be nothing left and the plaintiff would be left with an empty judgment. Now, my lord, I can't tell you what the value of that case was, but if you're talking about a $700 million judgment, and even just a compensatory aspect, even if you can only recover a fraction of it, you're still losing a great deal of money. So the fact that there was nothing left here is of no moment in our case. And then lastly, the paragraph at the bottom of page 7. And this is where he disagrees with Parker J on whether the words displayed are non-ambiguous and proprietary. And over the page you've got, can only have been uttered with the intention or an attempt to deter the plaintiffs from pursuing their rights. Well, we say it's very clear why this was said to Motorola on the eve of trial. Don't worry about your judgment. We're going to retreat. Don't bother pursuing your rights. Effectively. Mercifully, I think that's the authorities from my perspective. I did promise the transcriber I would seek a short break at 3 o'clock. So we didn't
I'm not
have
sure
all
that we
this
have time. We've got a lot to get through.
Yes, although I think having gone through the authorities, I can take the balance of my submissions relatively swiftly.
Well, when are you going to finish?
Ideally by 4, but no later than 4:05.
Well, I think you'll have to do better than that if you want a 5-minute break.
I was factoring in the 5-minute break to those estimates.
Well, you're going to have to finish by 5 to 4
5 to 4.
with a 5-minute break. All right, 5-minute break.
I'll do so.
Bound to say, if I'd known we were going to have breaks, I probably wouldn't have authorised the transcription service. There we are.
My apologies, my lord.
Lord Justice Lewison wasn't happy that had been asked because he never normally gives it at all. So, yeah, I just told him I won't go down well. Okay.
All right.
Hope you're not too late. 5 to 4, they're up anyway.
All right.
Thank you, sweetheart.
So it's this for tomorrow, is it?
Yeah, I don't know who's where yet. I haven't looked. All right.
No worries.
Take care. Be
See
careful.
ya.